we can say Parliament ana.
I'm a Parliament.
Na say uti speaker ruling no ene.
It's
And you say from now till December 1st. After December 1st there, you cannot hold yourself up as a member of Parliament. I just say court nankasa atna application for stay no so granted stay no answer. Anya sadia from December 1st you are no longer MP. What was saying?
oh, and maybe you. TV mini ame ho mi MP. Say MP nya fe na master TD. Mr. TD ya che. Me for 4 years. And na me fa another 4 years and then another don go akufo ado.
Yes.
And at this time dan ko ado masin aba. And I said you mabisia na esimishia. Me ane ekoso no na me kan ka che say momi
FM.
And I said you menya lawyer also. Metie speaker ruling no. He was just talking about the 7 days automatic stay.
Sure.
And no said you who file the bill, so one file the bill is an automatic stay. And see what they did yesterday was unconstitutional. That is all the speaker was trying to tell them.
Yes.
And that's automatic stay now. Sabio Emrane Diamano. It gives you the opportunity to initiate another process. And when that process is initiated, the lawyers can best explain. Because maybe let's just say we have to get the issue filed, appeal, and all those things of execution and all those things. So we must get all those things done.
Yes.
And when those things are done, it still means that his speaker cannot just declare redundancy vacant. So it's still the same conversation we are having. But near Canada, SBO, Emranum for Omona only omudi san komona a bit me abwa.
Okay.
But yena yam ranum for idea. Near me say, Sabio, the natural stay no, another automatic stay no, and ending on the 1st of December. That is what he has spoken about. But the other process will obviously continue, which we have even started. So the lawyers will take over from there.
It did not meaning say ubeti advice from the lawyers whether I mean say Mondays months to Parliament must sit from Tuesday and you take advice from your lawyers whether to go to the House on Tuesday or not.
Exactly. The lawyers will deal with that. The lawyers will deal with that.
Are you downhearted?
No. In one breath, let me say I am not happy. I'm not happy because I think there is an injustice that somebody just handed over to me. Serious injustice. But what do I do? Whether it is the law, is not the law, it is only God who knows. But I know within me, say, Obia handed over injustice, Amame, by the position he holds. And that is why I'm going for that appeal. So, whether I like it or not, I've decided to become a politician. And since I've decided to become a politician, these are things that I should be prepared to meet them. But I think that naturally, I've not been treated fairly. Legally. So, OBTS has some way, and some year, you can want some now. I'm start from that angle. But, Obi, you'll be an AMP.
Dabi.
You'll be an AMP. A big I try on the most of when we need that. Let's meet the Yamia, Madonna, Menko farm my opportunity, my 8 years. Now, almost have another opportunity. I mean, best save your mobile. Let me improve your life. Now, Sabi, BBC, ABC, Maquia. What will I do?
Yeah, and I'm a new dean Komori, Yanona, Yamia Domian Saka, lawyer for the petitioner, no, former MP and lawyer. And now, all three must say the main issue, or what they call court, no more argument, no, about on the breach of natural justice in the sense, time at the Besini see ya, ECA and again say, oh, change the coalition center, no, at the Akotamale, no. Easy are more money, indeed they were not aware, and that's how come and candidate ni hona ne rep be answer any tamale hobby. In no more told judge, and when a judge say you cannot build something on nothing. Inti say the coalition and kasana a wronger. Everything flowing from that coalition should be declared null and void. And it's now qualify for rerun. No, is that what happened?
Say someone no kind idea. Someone no kind idea. Obi, me anymore.
Yes.
Let me catch you say. Proceedings no. In that proceedings no. No chief witness and admittee say he was at the coalition center. One say. Eba mradia obi adintro that evidence na yedichere because yes I announcement no na me hobby na petitioner no ho ye nyina agents wo ho nti eno ne they would deny but on oath ono ye chief witness ojitu mu say he was at the coalition center when the violence broke only jitu mu sa omo witness jitu mu sa and he saw the police escorting the electoral commissioner going to an unknown place. This is captured in the proceedings. I didn't know.
No, Omo Kase, and yeah, where the violence broke. When the violence broke, coalition center near him, say near Pandai ho.
Exactly.
No, the new coalition center which was in Tamale.
If you take the CI 127,
yes,
Echira was saying. Where you are supposed to be present, you are present. But where you decide not to go, and then the exercise is done,
you cannot complain.
It's valid.
That's true. But almost say they didn't decide not to go. They were not informed.
That's what I'm telling you that. No, that's what I'm telling you that. The man himself said he was at the coalition center when the violence broke. Are you getting me?
Yes.
And he saw the police escorting the EC. And they were going. Masa, agent, what you man is saying? What you man is say? Overbo exercise na eko no ho ban. Wo na wo yigira ho ma wo nipa no ho no.
Yes.
Nti se obi e fa nema eko obi wuti we. Sabe wo na wo ho se asampa awia yi. Na wuti ho. Na sabe o krofo aba ho no. Abetam nema eko. Na wuti ho na wo hwe no. Na at the end of the day or the ade no kwa. No, Omobeka say, Conform more money, so the again continue on the point. Is that what you are going to say?
In the form, are you also saying, sir, from Pandai Coalition Center, Hono, move straight to Tamale Coalition Center, Hono?
Yes, from Pandai Station, the man, the security agencies were there, the military and all those people were there, and the man told us, looking at the youth and what was going on, if they decide to declare, there would be problem. Blood will be shed.
Yes.
So he spoke to the regional electoral commissioner, and the regional electoral commissioner asked that they should come and do the declaration, which has been done
in Tamale.
In Tamale. So we moved straight away from that place because when the announcement was done, he told them that look, this is the challenge they are having. So they are going to Tamale because the regional EC has asked all of us to come. Anyone who is interested, you should all go. Until we went out straight away with the military escort, with the police escort, and we left to Tamale. And when we got to Tamale there, their regional executives were there.
At the coalition center?
At the coalition center. The regional chairman, the regional secretary who is currently for the national lotteries.
Yes.
He was there. And there was one other man who is called Dr. He was also there at the coalition center. They took the pink sheet and told us that their people called them that we were coming.
Okay, but the candidate or his rep are Matamale Hobi.
They refused to go.
Okay, but you are arguing, say they were aware, say move to Tamale.
On one kasa kachire will say he saw the police escorting the EC. It's on oath, and this one is captured in the friend is saying in the witness statement.
Witness statement, sure.
He said it, and it is in the witness statement. In any case, we are dealing with laws.
Yes.
Say, Obi betimi deny, I'll be any evidence in and America say, if you decide not to be present, are you getting me? If you decide not to be present, it does not invalidate the results.
Yeah, that is right.
They know very well that some people can decide run to dodge and come and say tomorrow say they were not there. Uko friend saying,
yes.
Do you know where the declaration was done? It was done at the national
EC office. That's true.
There was no MPP agent there.
Yes.
Because they refused to go.
Yes.
Are you getting what I'm saying? Go, but the declaration was done.
But say I guess the real bone of contention and say because the CI is clear, say one, you have to publish the venue which is demarcated as the coalition center.
Yes.
If it becomes necessary, say there should be a change of venue.
Yes.
All the parties should be notified about the change of venue. What constitute notification and a problem? Into the petitioner says he was not notified about the change of venue. It is not on your way. That I think is where the bone of contention is.
But Obi, say, how do you then say that if the person was notified? Violence broke. We were all there. The chief witness says that yes, he was at the coalition center when violence broke.
Okay.
And he was also there when he saw the electoral commissioner
move to Tamale.
The police being escorted. One was the police are escorted from further. This man admitted that he saw it. Now, or see, he was not notified. That who notified us?
Okay.
Who notified us?
Okay. Okay.
But we knew we won, so we will not allow our verdict to be stolen by anybody.
Yeah.
So we followed. So that is why in the wisdom of the framers of the CI, they made it aware that if you refuse to go, your refusal will not invalidate the results.
Absolutely.
That is it. That is law. That is law. Are you getting me? In any case, pink sheets now, Obi want the pink sheets. So whether you are the coalition or you are not a coalition, you can collect your results.
Absolutely.
Yeah,
that's true.
And they admitted that they have all their 152 pink sheets. What is their results? They went to there and they said they didn't come there to display their results. Yeah. So coalition, the coalition is different from polls. At the polls level, if you are voting and there is a violence, that one, the processes is different.
Yes.
At that particular point, the EC officer must report to the returning officer, and then if they have to adjourn the vote, they will the process they will adjourn. And if they have to do it tomorrow, they will do it. That one, the publication is there. That one is general. That one is for polls. It is not for coalition. Because for coalition, you would have gotten your pink sheet. I would have gotten my pink sheet. So if you think that the electoral commissioner collated a figure and that figure was wrong, then you prove that yes, your figure was wrong. Looking at my pink sheet, these are my figures. So your figure is wrong. You have cheated me. But if you say that just because you were at the scene and coalition has been moved and you deliberately refused to go, and then the results was declared, that result should be nullified, should be annulled. And then Abba, please.
Very well. Honorable, I get your point. You better say, and we'll see what
facts are facts.
Sure.
If we don't let circumvent facts because we think that we have the power behind us. You see, other than that, tomorrow, I can deliberately also say that I didn't hear the announcement.
Yeah.
When they were going, I didn't hear. So, how do I prove that I heard it or I did not hear it? How do I prove? How do you prove? Obi. How will you prove it?
Yeah.
Because my announcement, so, yeah, kwaha. Nipa say one thing. May they across the party. At the end of the Nipa so catch was say, me who say, your coalition center, when I mean who say, police for Abefa Electoral Commissioner. Who admit you? Who say? Master, sabi, nyani awondene asam na yentimi nka. So, let's just say, Mrana Asia, ne de ba say, who want to now who say we should nullify the results at any argument. So that law is not valid any longer.
Honorable Mate, and the speaker didn't ruling about the Matthew Yendam situation over Pandai and flowing from the Tamale High Court judgment. No speaker Chirimoa, the rules of engagement no clear. Say when you file a stay against the order of the High Court, it will pen for 7 days. After which, the court na an effective directive staying the decision of the lower court. They are not just the High Court judgment. Would stay. It was saying from the minority side, you name say more issue statement or more condemning the behavior of the High Court justice, no. But with the speaker ruling, we Mojen is saying.
Okay. What it is, when a judgment is given, there's an automatic stay for that 7 days period.
Sure.
And so that speaker's argument within that 7 days, if you file state of execution, then you are right to have the execution stayed until the matter is properly heard. I mean, the truth is that me as a lawyer, I understand that there are two schools of thought, and the jury is still out there as to whether filing of state execution in of itself should stay the hands of a judgment creditor, for instance.
Yes.
You know, and for some of us on this particular case, the filing of the state of execution, which came immediately after the judgment, and that is what Trans refers to. Say within that 7 days, there was an automatic stay, and then he filed the state of execution within that period, and I say of course. And then so long as he's filed the state of execution and he's taking steps to appeal the decision, he believes that he should continue to hold himself out as an MP until the matter is finally determined. Always the issue, no. Honorable the firm of I think he was wrong on the law and he feels it's right. But I said, look, I obtain a judgment, about judge, empire copy of the judgment required by that's a different after list of execution. Pending one, receipt of the judgment, we are taking steps to execute his case. What do you mean? I said within that period now, say Kakran will do a this scandal now. And I said, turn it down, turn it, sign it down now. Execution, it takes time. It is a list of execution. You should allow him to hold himself out as an MP until the matter is finally determined. But sometimes judges now they look at the practicalities of some of these cases. So they will say that they will look at the case on its own merit.
Yes.
So we look at this particular case where judge say election within 30 days. There is a stay of execution. There is an appeal pending. The election now 2-3 weeks after judgment. Now, of course, they say the High Court was wrong. What happened? So I believe the speaker in his wisdom showed that look, it should be better if it stayed. And I'm sure when the Court of Appeal actually hears the matter, when they hear the particular motion for state of execution, also any speaker against they should stay all execution until the matter is finally determined. Because if you allow execution to go on, and so now, what they see as them Kasana, there will be no subject matter to even discuss. There will be nothing. And so the court look at every case on its own merit. And I believe that on the merits of this case, the court will do right by the people of Ghana, just like the Speaker of Parliament did, saying that under the Court of Appeal rules, once you file the state of execution, and in this particular matter, looking at the facts of the case, but this is proper. So the matter is stayed until the Court of Appeal itself hears the motion for state of execution. But on this one, I agree with him.
Yeah, but so what speaker ruling now, it throws out two different issues. Number one, and the speaker was quite categorical, said based on the automatic stay after the High Court ruling, which is 7 days, no, and none a speaker no at the year Juma in the Wakase, Matthew Yindam can hold himself up as member of Parliament, sit through Parliament proceedings, take part in the debate until the 1st of December, by which time as our automatic 7 days no would elapse. After the 1st of December, no, say court no entna se NTA application no and grantee stay na, then from the 1st of December he may not be able to hold himself up as a member of parliament. That is the speaker's ruling.
No, I think that is what I got from the speaker's ruling. Because I was in the chamber at the time. We were having a continuity. And I got the rendition from the write-up, Mema, Menkro person, the man. But the truth is that, maybe Jimmy said, "Sa automatic stay no kwana speaker can." Then I would disagree with him with respect because sa 1 week now, it's 7 days now.
Yes.
And yeah, no pet and here the fact that what finally stay of execution in itself. He filed it within the 10 days, within the 7 days.
Yes.
The fact that what finally stay of execution in itself, and in my view, because of the facts of this particular case, stay of execution is necessary. Because to me, and I said, I said no, after 7 days, maybe Court of Appeal ends at the end. He hasn't been assigned to the Court of Appeal, and it will be declared the seat vacant. Now, one man, you acquire election. I believe about the time you acquire election, you cannot say of execution, the application, you here application. All right, you acquire election, we are. Would the court be able to even hear that state of execution? Because then that means that
it will be done
get overreached the court. And you cannot do that once there's a state of execution. How can you go and hold parliamentary election? You would have overreached the authority of the court. That cannot happen. That cannot be the case. Because what happens is that then that application before the Court of Appeal becomes brutal fulfillment.
Yes.
It won't be of any effect. Yes. It becomes useless.
Yes. And that is what I wanted you to address, because from how you were speaking earlier, no, I got the sense you probably did not get the speaker's ruling well. Because the speaker's ruling, as your reporters in Nadia, all the media portals now report, and they say Matthew Yindam can hold himself up as MP, take part in the parliamentary debate and everything until December 1st, by which time the automatic 7-day stay after December 1st, he cannot continue to hold himself up if the court has not given an express way to the stay of execution. No? It is a court saying here application for stay now. After December 1st, he cannot hold himself up as MP. That is what the speaker said.
That would be interesting. Like I said, I mean, I appreciate that. I said I wasn't a committee.
Sure.
Because of the interview, I got the write-up.
Sure.
I didn't get that kind of understanding.
Sure.
But if that's what you're saying, then, like I said, I will respectfully disagree with the speaker, because it cannot be the case that after the stay, after the automatic 7-day stay, his application for stay of execution will mean nothing. No, it should mean something, because after that, so if you go ahead, because anyone know anybody tell me when the case is listed. Is not filing.
Yes.
The appellant is not filing the case. No. And then they determine when the case is listed, and when determine when the
application for stay will be heard.
Yes, will be empaneled. He had no hand. He has done his bit as a citizen. It is up to the judicial system to fix the date and empanel judges. That can take more than 7 days. No. The people of Banda will not be represented. Now, because of that, it will declare state vacant. No acquire election. When election, then the Court of Appeal get a date to hear the state of execution. They cannot hear the state of execution, because the motion would have been overtaken by events, and in this particular case, by the election. And it wouldn't make sense. The fact of this case dictates that there will be stay of execution of the judgment until the matter is heard.
But as you earlier said, even amongst lawyers and jurists, the verdict on whether the mere filing of the application in itself act as a stay. Lawyers are not even agreeable on a way forward, because unfortunately for the apex court no ensure that man one conclusive decision on that. Indeed, there are a lot of decisions, and I will refer you to the ex parte Alote case, Moffat, the popular Moffat case. No, the court said, and I quote, in effect, the court was saying, no, I think I would have to bring this part first. I'll say any conduct which tends to bring the authority and administration of the law into disrespect or to interfere with any pending litigation in contempt of court is contempt of court, Once the respondent became aware of the pendency of the motion before the High Court, any conduct on their part which was likely to prejudice a fair hearing of that motion or interfere with the due administration of justice amounted to contempt of court. In the hand, you could see, the court was clear. Once you get notice of the application, the status quo ante would have to remain. The decision goes on to say, in effect, the court was saying that the moment the application was served, the status quo was to be maintained pending the hearing and determination or until otherwise ordered by the court. That case will not apply here, and if it did lay down any rule that a person was automatically prohibited from doing the very act for which an application has been brought to court against him, that will be too wide a statement to be applied in every case, for which reason it cannot be affirmed. And you will see, even in the Moffat case, court may draw the extension. For some cases, that blanket way cannot apply. And you look, and as you said, it should be on the merit of each case.
Case by case. Every case will be determined on its merit. And that's what I'm saying, that the facts of this case and the merits of this case determine that the status quo ante is maintained once the application of stay of execution is filed. And see, it would be so wrong for anybody to say, in spite of the application I have filed, stay of execution shouldn't lie. And I can say, if we look at this particular case, imagine the consequence. You sell resources. I campaign. The application for stay of execution. How would that happen? That means that you are bringing the administration of justice into disrepute. You are overreaching the authority of the court. That shouldn't happen. And that is why I'm saying that if the speaker's ruling was up to just 7 days, then I respectfully disagree with him.
But Sisiano, what can then be done? Because the speaker, in his wisdom, ruling, we all agree, yes, the speaker's ruling, and a judgment of a court of competent jurisdiction. But at least within Parliament, the ruling would hold sway. Now we don't know when the court will fix the date. One, to hear the stay of execution application, and then also the substantive matter. And what happens after Monday?
Well, so we have a way we can bring a motion for review of the rulings of the speaker.
Of the speaker.
And so we advise ourselves, and we may have to take that option and lay the law out to him. I mean, look, speaker is an experienced lawyer and of course a legislator. He strongly believes in his opinion, but we also will do our best. We know any about Nasikana to the Derebra who will lay our position and then ask for his ruling to be reviewed, and he will go before him. And being the person that he is, if he feels that with respect he got the law wrong, he will admit and then review his ruling.
Yeah, but because the law on the mere filing acting as a stay, yenshe denya conclusive precedents ewo hono. What will be your argument to convince the speaker to vary the decision? Why no? Because the speaker can easily
the merits of this case and the consequence of the decision. The merits of this case, are very clear. If that decision is not varied, what we do is the people of Panda will be denied representation that the Constitution guarantees them. And that would be a solid argument. And we will lay bare the facts to him as it is. In this particular case, Nipana list of execution. He has no control as to when the case is listed and judges and panel. The people of Bandai need their representatives to speak to issues in Parliament for and on their behalf. And it's, while we await or abide the judicial process to get a case filed, they should be properly represented. And of course, you see, the authority and experts are looking clearly will lay sway, even though it is not blanket. If you read it, you see that clearly. The courts are saying that once you know that there's a pending application, don't do anything to disturb the authority of the court.
Sure.
And I'm sure the speaker will be willing to listen to us with the review of his ruling.
Very well. Lawyer, my yenna say bibiania and when him say o leader and so no speaker referring to the privileges committee. In fact, wakase prima facie he's engaged in a contempt of parliament or the number the privileges committee and also no are you aware of that ruling as well?
Yes, like I said, I've been told, and it's just interesting. Did say at the privileges committee, this matter will be dealt with. Look, this week I refer, and we are governed by our rules and the constitution. Speaker, I refer. The matter will be discussed at the privilege committee. Honestly speaking, I wish that we hadn't gotten here in the first place. Speaker will have to give a ruling on this. Sometimes, sometimes we need to be very careful. He's the leader of the whole minority group. Now, let me tell you what can happen. Because when you are referred to the privileges committee, you can actually be expelled from Parliament. It's one of the things. So, is that what they want to do, for instance? That the leader of the minority caucus should be expelled from Parliament? I mean, there's still a little easier. I'm not happy about it, but we will take it a day at a time. But I can tell you, some of these things from outside is meant to weaken the minority. But look, we are not swayed by that. We are stronger as ever. We are united as ever behind our leader. We will support him every turn of the way to lead us. This is not going to discourage us at all. That we can let everybody know, every Ghanaian, every party supporter should know that the minority is totally behind our leader. And we're going to go through this with him together, and we believe we will come up on top. We are not going to be worried about this at all. We'll go through the process because our rules require. But I can assure you, at the end, we'll come out on top of this.
But when you also say, apart from speaker referring to citing for contempt, I referring to privileges committee, there is also talk about the potential of, the court itself citing him for contempt. For any press conference or and sema or against the judiciary. Now we didn't the time or Kasan. What was running through your mind as counsel for the minority?
Honestly speaking, the facts will show that at the time I was debating.
I will debating. Okay, that's fine.
The budget.
That's fine.
And true, I'm making a budget. Financing is other country. I said Ghana Petroleum Fund. I can 1.1 billion. I brought 3.6 billion. No person will ye Ghana Petroleum Fund that say, yes, can all you need in Asa. Now, you Ghana Stabilization Fund, Ghana Heritage Fund, Ghana World Fund, near their boy in Timano. Minister for Finance, or near your president, as you said, you can open so we now educate Yamafo. Those were the issues I was debating on the floor.
Okay.
And at the time, I wasn't behind it, but I had. And look, sometimes let's call it state and not working too. Judge, and so we are still waiting for the judgment. But at least from what we all heard, it is so worrying that as a country we want to tolerate this. But a judge can say this. And the court to be so citing for contempt. Well, we'll see. Yeah, so we'll see. Wait, say number. Say court no citing. will be there to face the court.
Yeah, but do you think, sir, to say, sir,
Ukwada and Nebako? But
you think as an officer of the court, no, to say, sir, their court, no, AAA was a disgraceful conduct, and they were serving the interests of their paymasters. A good language to come from a lawyer of a standing.
Ashanti Martin is a minority leader. Ninipa, 1 year Juma Buan or Parliament. Court no far way in the figure. A hammer or the yaw any bread and a Kasai.
Very well. Honorable Mianasi, Bibiani Abesaba Bedin Komobio. Why?